The Supreme Court will hear oral arguments Wednesday in Trump v. Barbara, a case concerning the legality of Trump's executive order saying that babies born in the U.S. cannot be citizens if their parents aren't already U.S. citizens themselves or permanent residents. I'm Maggie McGrath, senior editor at Forbes, and joining us to discuss this landmark Supreme Court case is Jeff Lewis, an attorney based in California who is also a certified appellate specialist. Jeff, thanks so much for being here.
Thanks for having me.
Now, these oral arguments have been a long time coming. Can you take us back? How did this all begin?
Well, it began in the early days of the Trump administration when he signed an executive order banning birthright citizenship or denying birthright citizenship to parents of children who the parents are not here with legality if they came in here illegally. That's how we got here. And the ACLU represented a number of groups, parents of people who are going to be born after the effective date of the executive order, to challenge the law. And every court, every judge who's looked at this issue on the road to the Supreme Court has ruled against the Trump administration. And that's where we are.
Every court has ruled against the Trump administration. How important is that legal precedent going into oral arguments at the Supreme Court? Or does it not count as legal precedent in the eyes of the Supreme Court?
It doesn't count at all. The Supreme Court is called the Supreme Court for the reason that it is supreme. They don't have to defer at all to the lower courts on this case. But I will say this. At least 4 justices of the Supreme Court voted to take this case on. So that means at least 4 justices are not happy with how the lower court dealt with this case and they want to address it. So in terms of changing the outcome, there's at least 4 justices who aren't satisfied with how the prior judges have ruled on this case.
That's interesting. So does that provide some tea leaf reading even before the oral arguments? Is the court likely to undo what the lower courts have done?
You know, it's hard to say. You may recall last year this case was actually up on a procedural issue having to do with nationwide injunctions and class certification. And it could be that the justices took this case up because they saw it was a great case to deal with that procedural issue and they didn't care about the merits. On the other hand, it could be that at least 4 justices want to narrow the traditional scope of the 14th Amendment.
You mentioned the 14th Amendment. What exactly does it say about birthright citizenship? What have we historically understood the 14th Amendment to mean when it comes to birthright citizenship?
Sure. It says all persons born in the U.S. And subject to the jurisdiction thereof are citizens of the U.S. And the big controversies over those words, and subject to the jurisdiction thereof. What does that mean? And the Trump administration says if you are not here legally and you have a child here, you and that child are not subject to the jurisdiction thereof, and therefore you're not a citizen. Advocates of a broader interpretation of the 14th Amendment would say that phrase, subject to the jurisdiction thereof, actually only excludes from citizenship children of diplomats, children of occupying forces, those types of rare situations. And the fact that somebody was not here legally or the parents' lineage has absolutely no relevance. So that's the big issue that the court's going to decide.
How much do we know about the intent of the drafters of the 14th Amendment? I mean, the world has changed quite a bit, which obviously every Supreme Court case involves precedent and modern times compared to when the Constitution and when the amendments were written. But did the drafters of the 14th Amendment mean to include all children born here to citizens of other nations in moments when what the Trump administration calls birthright tourism wasn't as much of an issue?
Well, right. That's the $64,000 question. What was the intent? Now, the Trump administration is going to argue today that the task at hand, the big problem facing the United States when that amendment was passed, was a civil war was over. And you had this huge group of people who been brought here forcefully, slaves and their children. What was the United States supposed to do with their citizenship? And that was the narrow problem to be resolved by the 14th Amendment. The opponents of the executive order would say, oh, no, no, no. The 14th Amendment is broadly written. If they wanted to talk about the parents not having citizenship, there was a way to draft it in such a way. And the broad terms have been used intentionally by the founders of the 14th Amendment.
I was reading an analysis earlier that cited some reporting from The Hill and other sources that indicated that the court could hear arguments tomorrow and maybe defer on ruling on the 14th Amendment, but instead look at legislation, federal legislation from earlier in the 20th century, and maybe rule on procedural grounds. Can you talk about that at all?
Sure, yeah. If the Supreme Court wants to dodge or avoid the big, heavy question of what does the 14th Amendment mean, they could decide it on narrower grounds on what did Congress mean in the 1950s when they enacted an immigration law that used very similar terminology, meaning the subject to the jurisdiction thereof. And consider this, the amendment, the 14th Amendment sets the floor, the minimum of rights guaranteed to people, but Congress can always add to that. And so if the 14th Amendment only affords citizenship to a small group of people, but Congress expanded that to a larger group of people, the Supreme Court could just stick with a congressional law and avoid the 14th Amendment entirely.
Now, I referenced in a question earlier that the Trump administration has been using a phrase, birth tourism, meaning that people come to the U.S. specifically to give birth so that their children can have citizenship. In your experience, in your expertise, is birth tourism a huge issue today in the United States?
Well, factually and statistically, I don't believe it's a big issue. And historically, it's not a big issue. And it shouldn't be forefront in the justice's mind because typically the intent of parents coming over here has not been used in evaluating the question of citizenship. The big question is, were they born here physically, and are they the son, or are the parents diplomats or occupying armies? And if they don't fall into those categories, the reason somebody has visited the United States, whether it's birth tourism or something else, doesn't really come into the equation.
Now, President Trump said on Monday that the U.S. is, quote, the only country in the world that dignifies the topic of birthright citizenship. And I'm curious, I suspect the answer is no, but will the justices consider at all what other countries do when it comes to this and as they hear oral arguments?
Well, they shouldn't consider what other countries do as of today, 2026, but they certainly should consider what other countries were doing leading up to the 14th Amendment and leading up to Congress's passing of that law in the 1950s in terms of trying to figure out what the framers of the 14th Amendment or Congress intended in terms of the language of subject to the jurisdiction thereof.
Subject, such key words, and as ever precise in the world of law. In making his comments Monday, President Trump also seemed to attack the Supreme Court justices as stupid and dumb. Justice John Roberts had earlier this month warned about dangerous rhetoric, but could that backfire? The president attacking or at least criticizing the Supreme Court justices, could that have any sort of effect on how they hear these arguments and how they consider this case?
Well, look, the 9 justices are all human beings. They will have heard these comments and they're aware of them, but as justices, they swear an oath under the Constitution to call balls and strikes and just make decisions based on the law. I don't see those comments as being particularly persuasive to any of the justices. It's just, sour grapes from the most recent ruling on the Trump tariffs that didn't go to President Trump's satisfaction.
Now, oral arguments are happening on Wednesday, April 1st. What is the timeline for this case beyond Wednesday?
Nobody knows. I mean, generally, the Supreme Court adjourns before the summer, and they could wait to the very last day of their term to issue their opinion, or they could issue an opinion in a couple of weeks. Best guess would be in the May, June, July timeframe.
And in the meantime, for children who have been born here or are about to be born to people who are undocumented, what is their legal status? Is it in limbo?
It is in limbo, and I would broaden it out a little bit more to anybody who was born after March 1st of 2025 when the effective executive order took effect. So reaching back into time, there's lots of people who are in limbo, not just the babies and the parents, hospitals who have to figure out when babies are born, the paperwork that's involved. And do you just hand out a social security number to babies that are born? Do you require parents to come to the birthing room with birth certificates and citizenship documents? There's a lot of paperwork to be done if the law changes.
But up until this point, for babies that have been born, have they been given a birth certificate and a social security number, or is it state by state?
Oh, absolutely. As of today, before the Supreme Court has ruled, children born in the United States, regardless of their parents' citizenship, do get a birth certificate. They have citizenship. They get a social security card. They are entitled to all the benefits of being a U.S. citizen.
But depending on the outcome of this case, it could really open up a lot of legal uncertainty and a lot of chaos, I can imagine.
Absolutely. Absolutely. If you're a parent, a baby, or these hospital administrators that have to deal with it, or any state government that has to administer federal benefits.
Would there be, considering the executive order happened in 2025, a retroactive reconsidering of status?
Absolutely. I could see the Trump administration going back to March, I believe it's March 1st or the end of February 2025 when the executive order took effect. And I don't foresee the Trump administration offering grace to people born after that date.
It is a complicated and important issue. Have we missed anything? Is there anything else that you will be listening for or watching for in these oral arguments?
I'm going to be listening for any justices who are talking about congressional intent and the law that was enacted in the 1950s. Any justices that are asking questions about that law might be looking for a safe off-ramp to avoid deciding the heavier issues here involving the 14th Amendment.
Jeff Lewis, attorney based in California, thank you so much for joining us. We, as always, appreciate your insight, and we'll have to have you back to analyze what comes out of the court on Wednesday. But in the meantime, thank you so much.
Sure. Thanks for having me.